Hi, I'm attorney Mike Walls from Maronick Law Offices. We're here to answer your questions.
Okay, Mike. The clients want to know, what are the steps in a criminal case?
The most criminal cases that we handle begin with an on-site arrest. And that is when you were, let's say, for example, pulled over when you're driving your car by a police officer and he suspects that you may be drinking and driving, and he issues you a ticket for a DUI or a DWI. That is effectively an arrest. You're given a series of tickets. There are also criminal cases that begin when an arrest warrant is issued, and then the sheriff's office comes and executes that arrest warrant, and you're picked up. There's a number of ways that these criminal cases can begin, but the arrest is certainly the beginning of that journey. And that's where it's best to call our offices so we can help you with that. If you're arrested by a police officer on the side of the road one night, ordinarily you're taken for an initial appearance before a court commissioner. That's done within 24 hours of your arrest. And that also applies for any cases where you're arrested via a warrant. The initial appearance is when you are taken before a district court commissioner. The commissioner will make a decision as to whether or not you're a danger to public safety if you're released prior to trial, and whether or not you're a flight risk. And given the answers to those two questions, the commissioner can release you on your own recognizance, where you're released without having to pay any money. The commissioner could set what's called an unsecured personal bond, which is a promise to pay money if you fail to appear in court, but you don't have to pay any money to get out. The next thing the court commissioner could do would be to ask you to post a cash bond, where you do either have to pay a bail bondsman to post a bond, or you need to post money as a deposit with the court clerk's office in order to effectuate your release. The worst case scenario would be if the court commissioner decides to hold you with no bond, at which time you will spend the night in the county jail, and you're taken before a district court commissioner the following day for a bail review, where a district court judge would set any conditions of your release. Following that proceeding, the next step would be an arraignment. Typically in district courts here in Maryland, we don't have any formal arraignments. In circuit court, if you're charged with a criminal felony charge, the arraignment is an opportunity for you to be taken before a circuit court judge, and the circuit court judge will explain to you the nature of the offense, the elements of the offense, and any potential statutory penalties, including any jail time or any fines, and then advise you to your right to counsel. I will tell you now, your right to counsel is probably one of the most important rights that you have as a citizen of the United States or a resident here in this country. And it's important for you to immediately get counsel when you're facing any sort of criminal charges or serious traffic charges in the criminal justice system. So the arraignment will then also give the court an opportunity to schedule dates for a motions hearing or a trial, again in a felony criminal case. In the district court, you will get a trial date. And it's at that point where if you've retained our office to handle the case, we will have at that point discussed with you the nature of the evidence that the state's attorney has to present at trial against you. We've assessed the viability of that evidence. We'll also have an opportunity to discuss whether or not it's in your best interest, given the nature of the evidence, the quality of the evidence against you, whether it's to your advantage to take advantage of a plea agreement or have a trial in the case. We certainly, the next step would be a resolution of this case, either by way of a plea agreement or a trial. We certainly can help in the case when your best interest is to take advantage of the plea agreement. We can present evidence before the court that would mitigate any sentence and get you the best possible sentence. In that scenario, after a trial, if you are convicted, then we could certainly do the same thing to present mitigating circumstances to the judge to get you the best possible sentence given those circumstances. The very last thing in a criminal case will be your post-trial rights. You do have 10 days after either tendering a guilty plea or being found guilty after a trial. You have 10 days to file a motion for a new trial. We can assist you with that. You do ordinarily have 30 days in which to file an appeal in the case, and then 90 days to ask the judge to reduce or modify the sentence that the judge has imposed. And we can certainly help you with all of those post-trial rights and advise you of the consequences and any probationary disposition, how you would conduct yourself on probation. We can assist you with that, and we would be here for you through the duration. Any questions that you may have, we can certainly help you with all of that.